It's a great pleasure to be here. Thank you, Francesco, for inviting me to speak. And I'm going to speak about two cases in England called Astra and Spa. And I am not going to give a lecture. We are all going to play a game together. And the game is the question that I am going to ask you at the end of my speech. And the question is the obligation to pay hire under a time charter a condition of the contract? So for foreign lawyers in particular, let us consider terminology. What is a condition? A condition is a term of a contract, breach of which entitles the innocent party to bring the contract to an end at common law in England and claim substantial damages. And to put it in its context, let us assume you have a 10-year time charter. After 1 year, the charterer is 1 minute late in paying the charter hire at the end of the 12th month. 1 minute late as a result of a fault in the banking system. He was a perfect payer of hire, but on one occasion, he pays it 1 minute late. Question: can the shipowner bring the whole 10-year charter to an end and claim damages? That is the question that has been considered in two recent cases in England. One said yes, one said no. And that question will be considered in the Court of Appeal in England in June. But the Court of Appeal in England needs your help. And that is why, at the end of my speech, I would like to take a vote as to whether those here in the room think that a shipowner should be entitled to bring the whole contract to an end if the charterer pays 1 minute late or not. So please focus on that one question. You're all familiar with the standard wording. I think this is in the NYP form, that this is clause 5. I'm not going to read it all out to you, but there is no doubt that a charterer is obliged to pay the hire, and equally there is no doubt that if he is 1 minute late, the shipowner is entitled contractually to withdraw the vessel. I am not interested in that question. What I am interested in is whether the shipowner can bring the whole contract to an end and claim damages. What I'm interested in is the potential claim for damages. And this is, I should tell you, a difficult question. As I was walking through the Tuileries Gardens in Paris, I saw this statue, and that is how difficult the question is. This statue, this man from Greece, is thinking about this very question. That is the man in Paris. This is my wife, I should tell you. She also finds it very, very difficult. And this is me after I've had a shower, trying to work out what the answer is. As I've said, there are two judgments. One is called the Astra, Mr. Justice Flo, that said, yes, the shipowner can bring the contract to an end, even if the charterer is 1 minute late. And another judge more recently, Mr. Justice Popplewell, said no. And I'm going to go through their 4 reasons that they gave or were given. And at each stage, perhaps you might think, what is the right answer? And at the end of it, I'm going to ask you again what your overall view is. Well, the first reason given by the judge in the Astra was that the contract, as you've seen, provides expressly for a right of withdrawal, and that therefore, using his words, that is a strong indication that equally the shipowner should be entitled to claim damages. So the first judge says, because you've got a contractual right of withdrawal, therefore you also can claim damages. The second judge, he puts it in polite language, is that is completely wrong as a matter of logic. The one does not follow from the other at all. So that is the first reason. The second reason given by the first judge is that the general rule in all mercantile contracts where there is a time provision requiring someone to do something by a certain time or payment to be made, that means, in essence, that it is a condition. Where the first judge says, wherever you've got a time provision, that means if the charter in this case does not comply with it, the ship owner can bring the contract to an end, as I say, just if it's 1 minute late. The second judge, I quote it extensively there, but the short answer is the second judge said no. That is completely wrong. There is no general rule that time is of the essence. The third reason is there given by this is the second judge as well. He goes through the English cases explaining why that is so. The second or the next reason was that where you have an anti-technicality clause, that makes it clear that time is of the essence. So if you have a charter party with an anti-technicality clause, that is, it gives the charterer an extra few days to pay, and the charterer does not pay within that time, then that is a special reason for giving the ship owner a special right to bring the charter to an end and claim damages. The second judge said that is completely wrong. The one, again, has nothing to do with the other. There is then a further discussion about English cases, and I refer to them there. The leading old case in England is a case called the Brimnes, which is about 20 years old, where a famous judge, Mr. Justice Brandon, in that case decided that the obligation to pay hire was not a condition, so that if the charterer is just 1 minute late, the ship owner cannot bring the charter to an end. As Francesco mentioned, I'm an editor of a book called Scrutton on Charter Parties. That is a book that some of you might know. Ever since then, and indeed going back 50 years, Scrutton has always said, in effect, that it is not a condition. The third reason that is given by the first judge is the importance of certainty in commercial transactions. What that judge said is that there is a need for commercial certainty to require that the charterer pays exactly on time so that the ship owner knows exactly what his rights are or her rights are or are not. So he said if it is just a minute late, commercial certainty requires that the ship owner should be entitled to know his rights and bring the whole contract to an end. The second judge said again that is completely wrong. Certainty is achieved by giving the ship owner a right of withdrawal. There is no doubt at all about that. But commercial certainty does not require that the ship owner should be entitled in addition to claim damages. The fourth reason given by the judge was that by reference to other cases, you'll see them there, two Court of Appeal judges, Lord Justice Ritz in Stotsnier and Lord Justice Morbick in another case of Stotsnier, said in effect that the obligation to pay hire is a condition. The second judge again said, absolutely wrong. Those cases are in a shipbuilding context with different provisions and not the kind that you would see in the ordinary time charter situation. Then in Spa, the second judge listed a number of reasons where he said that payment of hire cannot be or should not be a condition. He says the express right to withdraw, that is the inclusion of a contractual right of withdrawal for non-payment, suggests that in its absence there would be no such right. There is a presumption, he said, that in mercantile context stipulations as to the time of payment are not to be treated as conditions. He said in some situations the breaches may be large or may be small. As I've said, going back to my first question, and that is, assume that charterer does not pay the hire for 1 minute due to a fault in the banking system. So it doesn't get into the ship owner's account by exactly the deadline. That it could be a trivial breach, it could be a major breach, and that suggests it is not a condition. And then he talks about the presumed objective intention of the parties and commercial certainty, matters that I have already referred to. And then he talks also about commercial certainty and what is or is not a sensible commercial result. Well, those are the reasons. I should tell you that the first judgment, I think, is 100 pages long, and the second judgment, I think, is 120 pages long. So I have attempted, in my 10 minutes that I have, to summarize one of the greatest battles of English law that there has been over the last 100 years. And it is vital to the way in which owners and charterers conduct their business. So that is the question that these two cases raise. Can the owners bring the charter to an end just because the charterer is 1 minute late? As I've said, the Court of Appeal is going to hear that in June of next year. And in a moment, I'm going to ask you, please, to give your answer to that. And there's no, in England, we say shilly-shallying around. It is either yes or no. No abstentions allowed. And the other thing I should tell you to help you on your way is that, as I say, I'm writing the Scrutton on Charter Parties, the next edition at the moment, and I have 4 co-editors. And all 5 authors of the book, including me, all agree what the answer should be. Whether or not the Court of Appeal will agree with us, I don't know. So if I may, Mr. Chairman, and you're going to vote as well, Francesco, please. You look worried. You can't wait to see. Is the owner entitled to bring the charter to an end and claim damages for the rest of the charter for 9 years just because the charterer is 1 minute late, not due to any fault of his own? All who say the owners are entitled to bring the charter to an end, all who say he is not entitled to bring the charter to an end. Yes. Who says it? I'll do it again. Who says he is entitled to bring the charter to an end, even if the charter is 1 minute late? Who says that the owner is not entitled to bring the end and claim damages if he's 1 minute late? Well, I think the noes have it. Well, that is the news from London, and this is the great battle that is going on, and everywhere in London, that is what we are talking about. Anyway, thank you again, Francesco, for inviting me to speak, and thank you all for listening and for your vote. Thank you.